Okay, why don't we get started? Again, welcome everyone to St. Edward's webinar on estate planning, investing in your legacy and to make a difference. I'm Gregory Perrin. I serve as the Associate Vice President for Development here at St. Edward's University. And we're very happy that you have joined us today. And we hope that the information that is going to be presented by Vince will benefit you in planning for your future and for your family. To begin, we have a few poll questions for you for us to get a better sense of who's attending and your knowledge of estate planning. So we'll do our poll, and then our presenter will begin. So our first poll question is, have you updated your will, trust, or estate plan in the last 5 years? So I'll give everyone a few seconds to respond. Okay. So it seems like our attendees haven't in the last 5 years updated their estate plans or wills of trust. So that's a very important thing to keep current, and we'll talk more about that in the webinar and why that is important. All right, so on to question number 2. Which of the following assets are taxable to heirs regardless of estate size? I'll give you a few moments to respond. Which of the following assets are taxable to heirs regardless of the size of the estate? Okay. All right, most everyone has responded. One more second if you want to get your response in or change it. Okay, so it seems it's pretty split amongst real estate, marketable securities, and 401ks and IRAs. And so again, Vince will explain the difference in these and which ones are taxable, which ones are not, and the benefit of those for your heirs. So for housekeeping purposes, if you have a question, please use the chat. We'll be monitoring the chat, and we'll be asking Vince those questions throughout the presentation. Right now, it's my pleasure to introduce Vince McElligott, who serves as our Senior Philanthropic Advisor here at St. Edward's, but as well as President of Advancement Solutions and Executive Vice President of Thompson and Associates. Vince has more than 35 years working with organizations of all sizes, their alumni and donors supporting universities, hospital systems, as well as nonprofits in this area of estate planning. So it's our pleasure to have Vince join us today. Go ahead, Vince. Thank you.
Well, thank you, Gregory. It's a pleasure to be here with everyone. What I'd like to do today is talk a little bit about some basic estate planning, and then also share some tax-smart ways to actually support the charities you care most about. So let me kind of dive in with one important question. I want you to just think about this for about 10 seconds. If you were given a large sum of money today, what would you do with it? And large could be whatever large means to you, maybe 50,000, 100,000, or much larger than that. But there's 2 stipulations. One, you cannot spend it on yourself, and you have to do with something with it right now. Okay. Now, when you think about that, I think one of the reasons this is really important is because it does pertain to the estate planning piece. When you think about what your answer was in your own mind, does that equal what your estate plan says? Because there is that one time in life when everything we own, no matter what the amount is going to go to somewhere else. It might go to others. It may go to charities that are important to us. it may go to the government. So if your plan doesn't do that, let's think a little bit more about that as we kind of move through the presentation today. You know, I've been an estate planner for a long time. I work all over the country with individuals to help them think through their estate plan. And one of the things that I often hear is that people with maybe wealth or celebrities or others, they obviously have a great plan. But there's a lot of mistakes that happen with everyone. For example, Aretha Franklin died without a will. Michael Crichton didn't update his estate plan to reflect his new family. And his new family, it was actually his fifth wife that was not included in his plan. James Gandolfino didn't take advantage of the unlimited marital deduction. So a lot of taxes happened with his estate because he didn't plan well. Uh, Michael Jackson didn't fund his revocable living trust. He had the documents in place, but until you title and fund the trust, it's not going to do what he intended, and it did not. Jackie O. Onassis had a tremendous amount of charitable intent and wishes in her estate plan, but her heirs didn't execute the plan. Etta James, perhaps you remember Etta James, a great singer from the past. She signed documents and executed a power of attorney when she no longer had capacity to do so. And so some of these individuals, obviously, we know as celebrities, but some of the other common mistakes that just ordinary folks make, not planning for income taxes on those IRAs or other retirement type plans. And those that did answer that question about what's taxable in your estate, regardless of estate size, you hit the nail on the head. And it is those retirement plans, these deferred tax plans are taxable to anyone we may leave them to. We're not planning for using the exemptions of both spouses. Today, the federal state exemption is very high. In 2025, it is actually 13,990,000 per person. So for a couple, right, a married couple, that's almost $28 million you could pass on as a couple to heirs. And so very, very few estates will end up paying the estate tax. Matter of fact, in this country this year, it's estimated that only about 1,500 estates that are settled will end up having a estate tax issue. And with some planning, probably many of those would not have had to pay estate taxes. Now, here in the state of Texas, there is not an estate tax, so we don't have to worry about that. But beneficiary designation forms often don't reflect those chosen beneficiaries. So when we think about those assets like retirement, life insurance, and others, when was the last time you looked at what that form said? It may have been when you started your job. And if that's the case, it's probably time to go back and review those again. Or even not tailoring our inheritance for the capacity or the needs of our heirs. Inheritance not protected from things we can't predict. We may look at children or heirs and say, you know, they're highly capable and able to manage an inheritance, but we can't always tell if that marriage that they're in will last, or if they're in a higher risk profession, they may be sued and there may be some liability. But the last one is really, does your plan impact and reflect your personal values, goals, and objectives? You know, ideally, estate plans should be thoughtfully planned. I've met many, many people who have not spent a lot of time thinking about this. It's just kind of automatic. Well, I'll leave everything to my spouse and then everything to the kids. But it doesn't take into any of those considerations in regard to your personal values and goals or tax ramifications or even the life circumstances of yourself and or your heirs. In reality, most plans are avoided. You know, we don't, we don't want to do them. We don't want to think about the end of our life. They're often done in a hurry, maybe done sitting down with an attorney and says, I need a will. And the attorney says, what do you want? And then you say, I need a will. And there's just not a lot of thought put into those. Sometimes they result in taxes and things that wouldn't necessarily be paid. with a little thought. And then other times when people do not understand what their will or trust says, sometimes they don't sign them, or maybe there's one spouse that doesn't sign those, so they're not complete. Now, when we think about estate planning, most of us think about this fourth box, transferring our assets to heirs or other beneficiaries. And yet, estate planning should really reflect all four of these boxes. One, we're accumulating and building an estate when we're younger. When we're in retirement, we want to maintain and that standard of living. But we should also provide and plan for the possibility that we may have a diminished capacity sometime in our life. And so we want to make sure that we have the other documents in place, things like a power of attorney for health care, a power of attorney for financial matters, sometimes called the durable power of attorney. And then at the end of life, some of the decisions that we want for our own care are really what's that directive to physicians. So it's not just about who gets our things. An estate plan should be a comprehensive look across the span of our lifetime. And then in times potentially when we're not able to care for ourselves, identify and give the power to those people we trust most to look out for our best interests. Now, I tend to think estate planning should be really reflective of you personally and your values. What's most important to you? And I think in many ways, it's answering three primary questions. One, do I have enough for myself? And if I'm married, myself and my spouse for the remainder of our lives to live in the way we'd like? And then two, what would we like to do for our heirs? And when we think of that heirs, without a plan, the state of Texas, or if you're in a different state, that state has intestacy laws and their plan is going to follow the bloodlines. Now, your heirs could be anyone, right? It could be your friend from college. It could be your next door neighbor that helps you out or whoever, but it's often children or grandchildren. So when we think about each of our heirs, they may have different abilities, right? And they may have different needs. So two parts of that question I think are really important is one, how much do we leave them? And the second part is what is the best way to do it? And I think that's the tougher question that many of us face. And then the third question, there is a part of our estate that I would call social capital. It's either the portion of your estate that you cannot give to your heirs or someone else that's either in the form of tax, maybe to the federal government or the state, or potentially directed to those charities you care most about. And that social capital, we often have choices on how we may direct that as well. So some of the things that I like to think about, if we identify our values, then we can set the destination. We know what our goals are, okay? And then we develop plans and employ tactics to reach those goals. Everyone's family is unique. Everyone's situation is unique. And so a plan should really reflect your personal goals and objectives. Some of the common values that I often hear, I would really want to benefit my family. Vince, if there's a way we can minimize taxes, I would like to do that and potentially support those organizations that I've supported for many, many years. You know, what influences your plan? Clearly, over time, there are internal factors that impact you personally. Maybe it's changes in net worth, or your family may have changed over the years. Or those individuals that maybe you've identified, if you've created a will or a trust in the past, and some of those folks are no longer able to serve in those roles, we might want to update our plan. Potentially, your goals may have changed over the years. I do know there are external factors that are at play right now. 7 years ago, the Tax Cuts and Jobs Act doubled the size of the federal estate exemption amount. In 2019 and 2022, additional laws came to place called the Secure Act and Secure Act 2.0 that changed the way retirement plans are treated for non-spouse heirs. And there are some other factors that changed in each of those laws. This year is a year of tax reform. We know that the Tax Cuts and Jobs Act will expire at the end of 2025. And currently, there's conversations in Congress about either extending those or making changes to those. And we do know something's going to happen this year. We're not exactly sure what that might look like. Now, when we think about our estate, I think there's really two parts to your estate. Here on the left-hand side of the screen, there are assets that are going to be governed either by your will and pass through the probate process, or potentially governed by your revocable living trust if they are titled to your trust. Now, things like your home, business, other real estate you may own. It may be commercial real estate. It may be a vacation home in another state, farms, bank accounts, other taxable investment accounts, personal property. All of these assets are governed by your will or your revocable living trust. These assets will also get what's called a step up in basis. So for those of you that answered the poll question that says, home or real estate may be taxable, it will not be taxable if your estate is below the federal exemption amount. So all of those assets, your rental property, your business, will pass to heirs tax-free without any capital gains tax or estate tax. Now, I can't say the same about all of the assets that are governed by a beneficiary form. These assets are governed by a contract. So it really doesn't matter what your will says. It matters what the beneficiary form says. So for those workplace savings plans and traditional IRAs, those assets are all tax deferred. So these assets have been where you've contributed to these in your work years, and your hope was to begin taking these out in your retirement and using those for your retirement years, and hopefully maybe leave some of these for your heirs as well. These will all be taxable to you. Now, the Secure Act changed the way these assets are treated for non-spouse heirs. So in 2019, we can still leave these to our spouses, and they can stretch those out over their lifetime. But our children and other heirs are no longer able to do that. Now they have a maximum of 10 years where they have to withdraw all of those funds. So those assets are taxable to us, they're taxable to our spouses, and they're taxable to our heirs. Now, they're not taxed on transfer, they're taxed on distribution. So if we leave your 401k to your son or daughter, they have a choice. They can cash it all out as soon as they get the call from Fidelity or Vanguard, and they'll pay the maximum tax, okay? They'll pay the tax based on their personal tax rate. So anything that comes to them would be taxed at their personal tax rate. And they also have a choice to roll it into an inherited IRA. So if they roll any of these assets into an inherited IRA, they have a 10-year window to withdraw those funds. So those are assets that are subject to tax, and those that are charitably inclined, knowing what we know right now about these assets that are taxable and not, that's often the bucket where I encourage people to make their charitable gifts. And the reason being, well, charities are tax exempt. So if we leave a portion of our 401k or IRA to St. Edward's University or the church or some other charity, guess what? They're going to get whatever we leave them. No taxes will be due. So rarely does everything go to our heirs, okay? We really have three buckets, right? We have heirs, we have potential tax, and perhaps charity. So if you don't have a plan or an estate plan, and I would say about 60% of Americans actually pass without even the basics, a will, there is no charity in those plans, okay? There may be taxes in those plans. So by default, we may have two buckets, but really there is a third. So when you think about your personal goals and objectives, which buckets would you rather provide for? I want to go over a little basics of what's in a will. So our last will and testament is an exordium clause. This says, this is my last will and testament. We identify the decedent, the person who had passed, and the heirs. Okay, we may make specific bequests of certain property or cash to individuals. We make residual bequests after all the other bequests are fulfilled. Then whatever's left over is going to go to these individuals or these charities. Or we can make contingent bequests. If somebody predeceases you and that bequest fails to be realized, we may make a contingent bequest to someone else. We also select the individual who we want to serve as our executor or our personal representative. Now, that could be a family member, it could be a spouse, it could be a son or daughter, it could be someone else. The basics of a revocable living trust, number one, it allows us to skip probate. And for a lot of people, this is a benefit. Probate takes time. It may take a year and a half or 2 years. There's fees, there's court costs, there's attorney fees, and things like that. In states like California and Illinois, and I would say New York, where probate is very expensive, most people are trying to avoid it. And so they will create a revocable living trust as well. And that's the core of their estate plan. Revocable means we can change it during our lifetime. If we create a revocable living trust, we are the grantor of that trust. We are also the trustee. We could have a trust for ourselves. We could have a trust with our spouse. It could be a joint trust. During our lifetime, that trust uses our social security numbers. We can make any changes to that trust. We can update that trust. We can restate that trust. At the grantor's death or disability, and if it's in the case of a joint trust with our spouse at the second to die, then a successor trustee will step in. At that point, it will become an irrevocable trust. The successor trustee will get a new tax identification number, and that trust will not be changed. And the irrevocable trust and the trustee will follow our goals and objectives for either holding those assets for the benefit of our beneficiaries or making distributions based on our goals. So during lifetime, we are the grantor, the trustee, and the beneficiary. Okay. And when we're gone, someone else steps in as a successor trustee, and our beneficiaries may be other individuals. And they could be income beneficiaries or potentially just beneficiaries outright. So when we think about an overall estate plan, it's really about building a house. We want to have our medical power of attorney and our living will or directive to physicians. We want to have the property power of attorney dealing with those financial matters. Remember, those are in case we are unable to make decisions on our own. Maybe we've gone into a memory living facility and maybe our primary residence will need to be paid, and our son or daughter now has the power to go forward and do those things for us to make sure that we have the resources we need. Now, the power of attorney, they have a fiduciary duty to you, the individual that they're doing this for. They don't become owners of your property. And so that's a real important distinction. And then we have the last will and testament, perhaps the revocable living trust. So those are really the core of our estate plan. And depending on what your estate looks like, and your goals and objectives, we may have other types of trusts, maybe a credit shelter trust or a marital bypass trust or a life insurance trust, and some advanced planning tools as well, depending on estate size and your individual charitable and non-charitable goals. So when we think about our heirs, the typical default plan is, well, at the end of my life, everything goes to my spouse. Then at the end of my spouse's life, everything goes to the kids. That may not be the best strategy. When you think about your heirs' abilities, you think about their ages, maybe you have a child with special needs or other issues. Maybe it's even asset protection, liability protection you might want to provide for them. Maybe you have a son or daughter that you're a little unsure if their marriage will last. How can we provide some protections to make sure that those assets we provide don't leave the family? Well, we can provide an annual stream of income. We can provide lump sum distributions over time. So when we think about these types of techniques, now we're talking about holding those assets in trust for the benefit of our heirs. Now, this is my family, and I think I lost my spouse about 8 years ago, and lucky to remarry this wonderful woman in the middle here, Renee, and we have a blended family. And I'm a big believer in philanthropy. I work with charities across the country. And when I think about my estate plan, I don't feel I have to disinherit my family to also have a charitable plan. So when I really think about this, if my kids can't get by on 95% of my estate or 90% or whatever you think is best, they probably can't get by on 100% either. So I think we can support those organizations that are important to us as well. So where should you start? When we think about our family, we want to obviously think about their needs or other concerns we may have. Do we want to include children? Do we want to include grandchildren as part of our plan? We tend to live a little bit longer. The gentleman in this picture is actually my father. He passed in 2020. He had a charitable plan. He had 3 entities that he was supporting. His high school, his Catholic high school, scholarship fund for the benefit of my mother who passed 30 years ago, and his church. And when we think about my 7 brothers and sisters, obviously the bulk of it was distributed to us, but he wanted to also include those things that are important to him. And so there may be some organizations that you too might want to support. Sometimes, charitable gifts can really make sense in an estate plan, especially when we have appreciated assets, but we're kind of dread the tax bite if we sold it. Perhaps we want to increase and improve our income situation during our lifetime. So there are some strategies that can be employed now, and then some strategies that might be employed when you're gone. Maybe you have a child with special needs, or you have other concerns, and so often I think we miss sometimes the opportunity to look at the charitable tools to truly make a big difference in our estate plan, either to provide for ourselves or potentially provide for our heirs. I mentioned retirement plans earlier in estate planning, and most IRAs are funded with pre-tax dollars. Obviously, the Roth IRA is not, but payouts come out as ordinary income, and typically that's high taxation. We can change the beneficiaries. We can update those forms at any time. It is totally fine to have charity and family as part of that beneficiary. It just has to add up to 100%. Think about an individual, a couple here, that had a bequest in their will for their favorite charity. And so their will, at the end of their lifetime, there was $100,000 that was going to come to the charity. But if that gift instead comes from their IRA to the charity, the kids would actually be better off, assuming a 30% tax bracket, because all of those IRA dollars would be taxable to their heirs. So if some of those IRA dollars are one third of those, that $100,000 gift comes from the IRA, goes directly to charity. Now those dollars will not be taxed, and the heirs will get all of the tax-free assets. And so the net gain to heirs will be $30,000 better off. So how does that work? Assuming a $1 million estate, everything goes to the surviving spouse. I think this is an important distinction. And the reason I say that is that we want to make sure that everything is available should that surviving spouse need those funds. But at the end of the second life, the beneficiary form on the retirement plan allows $100,000 to go to the charity, $840,000 of other assets, plus the remaining $200,000 that's in the IRA, totaling $840,000 goes to heirs. Now, the heirs are still going to pay taxes on the $200,000 from the IRAs. They'll pay about $60,000 in taxes overall from this plan. And this doesn't change the intent that these donors initially had. What it does, it just changes the tax situation. So part of the dollars that would have gone to the IRS are now going to support the charity, $30,000, instead of the IRS. Here's another scenario. Laura, the faithful donor, someone who contributes consistently to the charity, has an estate about $200,000 in IRA, $300,000 in a home and some other assets. She's single, philanthropic, has a long history of giving. Her estate includes a gift to her favorite charity, and she wishes to make a larger gift now because she wants to participate with the charity's recent campaign. However, she's concerned about reducing her income. So one option that Laura has is actually make a gift directly from her IRA to a what's called a qualified charitable distribution, to a charitable gift annuity. Okay. What this does, it allows Laura to receive a lifetime income from a charitable gift annuity. She'll make a gift in this scenario, transfers $50,000 from her IRA to the charity, and they promise to pay her based on her life expectancy, a interest rate annually for the remainder of her life, no matter how long she should live. And at the end of her life, whatever's left in the charitable gift annuity will go to benefit the charity. Two things are important here. One, she gets a lifetime income. Her distribution counts as her required minimum distribution in the year the gift is made, and she has the benefit of knowing that she's already done something for this charity that's important to her. I'd like to talk a little bit about John, the reluctant investor. Retired professor, had an estate valued about $3 million. John has two children. He's tired of managing his rental duplex. It's valued at about $1 million, but he likes the income. And he has about $1 million in retirement funds. He's interested in leaving a gift to charity in honor of his late wife. One scenario that John might consider is creating a charitable remainder trust and transferring the real estate, the duplex, into the trust. He gets to avoid he has a tax-free transfer into the trust. He avoids the capital gains tax had he sold the property outright and then made a gift. He gets a charitable deduction of about $374,000, which he can use against his taxes this year and for up to 5 additional tax years. Plus, he gets a lifetime stream of income, or potentially up to 20 years for a trust. And so let's assume that trust grows at 5% and it pays out at 5%. John will get an annual income of $50,000 a year. And over a 20-year period, he would get an income stream of $1 million. And assuming, once again, it grows at 5%, it pays out at 5%. At the end of that term, let's say it's a 20-year term, $1 million would still be in that trust, and that would be the gift left to charity. Let's assume John likes the concept of having his real estate go to his two boys instead, and they get a step up in basis. And he says, I'll put up with the management for a few more years, knowing that they're going to get that asset and they will pay no taxes on it. Instead, John takes his $1 million IRA and puts it in what's called a testamentary charitable remainder trust. John's retirement plan goes into the trust. It's a tax-free transfer. So they sell everything in his IRA. It's invested and it's set up as a 20-year trust providing income to his two boys. So at the end of his life, this happens. And his two boys get that income over the next 20 years, $50,000 a year. They'll receive $1 million in income, assuming once again it grows at 5% and pays out at 5%. At the end of that term, the remainder to charity will also be $1 million. So either scenario might appeal to John in this scenario or in this situation. So when we think about estate planning, we can be generous to heirs and still be charitable. I encourage you to think about your own estate, what you would like to accomplish. Really begin with your values, set your goals, and create a plan with a will and or trust to achieve those to achieve those goals and objectives that you have. It should be personal. It should be about you. And with that, I'm going to turn it back to Gregory, and happy to answer any questions.
Thank you, Vince. One question is, if I have a trust, do I need a will? What are your thoughts on that?
Great question. Yes. And let me tell you why. Often when we create a revocable living trust, your attorney will also create what's called a pour-over will. And the pour-over will is similar to, say, taking whatever you forgot to put into your trust and taking it and pouring it into the trust. So it's just our hope is that everything is titled in the trust, and then that will not need to be used. But if we inherit something from someone else, it's put in our name, maybe we have a bank account or we purchase a car or we do something else and we don't title it to the trust, guess what? Those assets that sit outside of the trust will not be governed by the trust. So that's why a separate will, or what's called a pour-over will, is so important. Now, the will is very simple. It just says, hey, look, if there's something out here that I forgot about, and that will have to go through probate, put it into the trust. And then the trust will serve as your your core of your estate plan.
Okay, thank you. Are there any other questions? If you have any other questions, you can chat them now of any of our attendees. I'll give you a moment to get that in. Vince, while we're waiting for that, you had mentioned something about a revocable trust or a living trust. How does that work if I'm still alive? I mean, do I have control over my assets?
Yes, yes. A revocable living trust or a living trust are really the same thing, right? We create a revocable living trust to often avoid probate. It's the core of our estate plan. The reason we might want to title our assets in this trust, and let me give you a great example. If we pass away here in Texas, probate's not that expensive. It's not that complicated. It's not terrible. Okay. Now, if I was in another state, maybe I would have a different opinion. But I'll tell you, it still takes time. Okay. You have to go to the probate court. It's a public process. Okay. And there's time and there's fees. And if, for example, we have a business, there may be some things that make it more difficult to operate that business because now it's in probate. If we don't have liquidity in the estate, maybe there's other issues. So a revocable living trust can really be a great tool, especially if we're disabled. If we're in a memory care facility, or if we have an accident or an illness, we can have someone step in and serve as a successor trustee, and we don't have these issues. Now, with a revocable living trust, there's also a benefit of privacy. Okay, and so it's not a public process like probate is. You have a nosy neighbor, you don't want everybody to know what you've done. A revocable living trust is a wonderful tool. Another excellent benefit of revocable living trust is if you have a vacation home, say in New Mexico or Colorado or California or any other state, guess what? And you only have a will, you have to probate in every one of those other states. Okay. You're going to have an ancillary probate, which is additional time, additional fees. Whereas if your vacation home in New Mexico, Colorado, or wherever is titled in the trust, now we've avoided not just one probate, but two or more. Okay.
Thank you. Thank you. Well, everyone, this concludes our webinar. Thank you, Vince, so much for your presentation and for that information. For our attendees, you will be receiving a post-webinar survey. We hope that you will complete that. You'll get that in your email and let us know if you have any additional questions and anything that we can improve perhaps in the future. And I will be reaching out to answer any of those questions and provide any information that you may have about what today's presentation, as well as about including St. Edward's in your estate plans, if that's your wish, or if you've already done that, a way to let us know that you've done that. Thank you again, and have a good afternoon. We appreciate you.
Thank you all.